Good morning. My name is Andres Knobel. I am a lawyer and I am a member of the Tax Justice Network. The idea of this presentation is to speak about complex ownership structures and to understand how these can affect beneficial ownership registration or identifying who is behind a legal vehicle, such as a company, a partnership, a trust, or a foundation. I am part of the Tax Justice Network's team working on the Financial Secrecy Index, and this is a database and an index that assesses the legal framework of more than 100 countries or jurisdictions, where we analyze, among other, the legal framework and the transparency legal framework on the registration of companies, partnerships, private foundations, and trusts. And the idea is to explain, based on our experience, what are the typical loopholes and problems with the ownership structure and the transparency side of many of these legal vehicles, and what to do about that. So we're going to start with the presentation. So the idea here is to introduce the concept and the importance of legal vehicles. And I refer to legal vehicles because not all of them are legal entities. Now, the main difference that we have is that a person, what you see on the left, who we will very likely call the beneficial owner, might own assets or a bank account or even transactions or just be involved in a contract under its own name. In that case, it might also be a nominee, but at least we would be speaking always about natural persons. And natural persons are limited in numbers. I mean, so far we have about 6 billion people in the world. So natural persons are usually registered, or there is some identity about them. Now, the situation is that in many cases, and in most cases actually, especially those involving either illegal activities or just someone trying to remain hidden or just to organize their affairs in such a way, they don't hold assets, or they don't hold a bank account, or they do not engage in business and in contracts under their own name, but through legal vehicles. So in that case, it would be the company, the partnership, or the trust that owns the house, or that has a bank account, or that is engaged in an extractive contract, for instance. And in those cases, it might be very difficult to determine who is the natural person, who is that beneficial owner, who is really benefiting and controlling that legal vehicle. So the idea here is to understand what are the typical complications and risks with these and what to do about it. The Financial Secrecy Index assesses and classifies legal vehicles into 4 different cases. We have companies, partnerships, and foundations, which are all legal entities, as the Financial Action Task Force on Anti-Money Laundering also understands. And then we have trusts, which are very famous and became very famous recently in many scandals, but they are considered legal arrangements. And we will see very shortly the difference between this and the implications this has for transparency. Basically because the legal entities usually have to register and they have to be incorporated in order to exist, whereas legal arrangements such as trusts or their equivalents such as the WACF, fiduci, fideicomiso, or the treuhand, they many times are considered mere arrangements, something very similar to a contract, and they do not need to be registered. But let's start with the most typical case of a legal vehicle, of a legal entity, which is a company. Companies in most cases have to be incorporated or registered in order to exist, and many people use them just because they offer limited liability. That means that the shareholder or the owner will not respond with their personal assets in case the company has a specific debt. Now, in most cases, and the most common case is when a company is limited by shares, and that's when we have shareholders. But what could happen is that a company might also be limited by guarantee. Many countries do not have this option. They only have companies limited by shares, but many tax havens or many countries in many common law countries have this option of companies limited by guarantee. And the difference is that shares can be transferred or can be sold, can be alienated, whereas membership through guarantee cannot. So this is sometimes used for asset protection purposes. Now, the shares, which is the most common case, might involve economic rights, such as a right to obtain dividends from the company, and or they might involve political rights, such as a right to vote in the General Assembly and just to decide on what the company should be doing. But it is also important to know, and so shares might have either one of them or the other one or both. But in some of the cases, what we have is we have debt which is convertible into shares. So a person who lent money to the company will have this debt which is convertible into shares in case the company doesn't pay back. So this creditor might actually become a shareholder. And one of the worst transparency risks that we currently have in many countries are bearer shares, or sometimes warrants or debentures. And what happens is that in this case, the shareholder is any person holding the material paper, the paper itself, which is a share. So as long as you give this paper to someone else, then you have just transferred the shareholding, and this other person holding this piece of paper will now be the shareholder. And that means that it might be impossible to find out who is a specific holder of that bearer share in a specific time. And that is why it is such a big transparency risk. The most common types of companies are the corporation or the SA in Spanish or French, or in German the Aktiengesellschaft, the AG. The other very typical case is the LLC, the limited liability company, and again the SARL or SRL in Spanish, or GmbH in German, and many other which are called the Sociedad Commandita por Acciones, or SCPA, or Kommanditgesellschaft. Something with the word Kommandit is usually to refer this, as long as it is limited by shares. Otherwise, we would be speaking about a partnership. But many countries also offer investment entities or companies, and we would have a holding company, or for instance, in the case of Luxembourg, some companies might then get one or become one of these specific types of investment entities, even though they are still a company, such as a SICAV, SOPARFI, or SPF, which is a special purpose fund. So these are different types of investment entities. But what is also interesting is that many countries, especially tax havens, what they offer is actually offshore companies. And they are many times called international companies or international business companies, or sometimes exempted companies. And what this means is that these are companies that are created and registered and incorporated in a tax haven, but they can only operate abroad. So they cannot have any asset in that tax haven. They cannot engage in any business or in any transaction with a local from that tax haven. All of their operations have to be done abroad. And a very complex case is the case of protected cell companies, or PCCs, which originated in Guernsey, but now they are available in Seychelles and in many other countries, or the case, which is very similar, of series LLCs like they have in Delaware in the US. And the idea behind these two types of complex companies is that there is, in a way, an umbrella company which has then many separate cells or many separate LLCs within this big LLC. And many times, or originally, this was used for the insurance sector, because each cell might have a different shareholder, a different owner, might have different assets, different balance sheets, and they are completely independent from each other. But from a transparency perspective, they are relevant because it might be very hard to know which cell you're referring to if they all have the same name or number, or if you're trying to find out who is behind one cell, and then the company or someone finds out that you're trying to obtain that information, the PCC in itself, the whole umbrella company, might just migrate somewhere else or might dissolve or unregister so as not to get any information. So this is, in a way, a company within another company, and that is the complexity that might create a risk for transparency. So what are the transparency risks in general? The main one is when companies do not need to register. This is not very common, but in some countries this is possible, and so we might have a company or a partnership, sociedad, which is the term at least in Spanish, de facto or in practice, or de hecho, which is just an entity which is not registered. Another thing that might happen is that only the subscribers have to be registered, but not the shareholders. And the subscriber might just be the lawyer or the corporate service provider who is the one who signed all the papers, but who's not really owning anything. They just did the paperwork. Another thing that might happen is that even if the founders of the company have to be registered, there will be no update of information upon any transfer of shares. So whatever information is in the registry is not updated. It was just the first time the company was created, but we don't know who currently owns the company maybe 5 or 10 years later. Or what might happen is that the update only happens for the top 10 or 5 or 1% of shareholders, but not for everyone, or not every year. And worst of all is that we could also have no beneficial ownership registration. Actually, unfortunately, this is the case in most countries still. Or that even for countries that do have beneficial ownership registration, they do not require listed companies, so any company listed in a stock exchange, to provide beneficial ownership information. Now, this would not be a problem if the listed company has at least provided that beneficial ownership information to someone else, to the supervisor, to the stock exchange, to someone. But if we just automatically exempt all listed companies just because they're listed, maybe we will be preventing ourselves from finding out who is behind those listed entities. The other problem with ownership itself is that in many countries, especially common law countries, nominee ownership is legal. In other countries, this is illegal, but again, in many countries, especially common law countries, this is legal, and this can be either a professional person or just a non-professional person who offers his name or her name to be registered, although they hold the share on behalf of someone else. But the main problem, as I said earlier, are bearer shares. Now, many countries have started to regulate bearer shares, and it is not the case that bearer shares are fully available in most countries. But this is usually not done properly. So what might happen is that a private custodian will have the information, or the company itself, but not a government authority, not the public authority. So again, it might be impossible to know who is behind it, because by the time we want to ask the company or the custodian who the owner is, again, their client might be the criminal itself, so they will unlikely tell us the truth, or they will try to erase any evidence. Or what might happen is that even if a country requires bearer shares to be immobilized or to be registered with a public authority, the problem is what happens for those bearer shares that haven't done so, so any pre-existing share. And many times the laws do not cancel bearer shares that haven't registered, but they merely suspend the right. So a law might say, well, if you are the holder of a bearer share and you haven't registered that, you might not be allowed to get a dividend, or you might not be allowed to vote. But again, if someone is trying to remain hidden, dividends or voting might not be a big issue. So they might still remain hidden until they decide to actually go and register the share. And that should not happen. Countries should say, by this day, say 1 year after the law has been published, any bearer share that hasn't been registered should be cancelled and should become void and just a worthless paper. Now, in this scheme, you can see, if we think of a big joint venture involved in a extractive in the extractive sector, we could have a problem if, say, company 1 is actually owned by an international business company from a different country, and when we try to find out who is behind that IBC, what we find out is that this IBC only has bearer shares, so it will be impossible to know who is behind it and who is the holder in a specific time. Another thing that could happen, which is not as bad, is that company 4, instead of having the beneficial owner directly registered, might simply have a nominee who might be, again, a lawyer or just any person using his name on behalf of someone else. Now let's move on to a different kind of legal vehicle, and now we have partnerships. Partnerships are similar to companies in that in many countries they are required to be incorporated or registered, but in other countries they simply do not have legal personality, so they do not need to be registered. In other countries they might still have legal personality, but they are fiscally transparent. So a country might not have much of an interest in the partnership itself, but would have an interest in the partners, so the owners of the partnership. And Partnerships might have limited liability, unlimited liability, or both. And instead of shareholders, they usually involve partners. The common types are the general partnership or sociedad colectiva, société non collective. And these are partnerships that have unlimited partnership in most cases. Then we have the limited partnership, or LP, or Società en Commandita Simple, or a Kommanditgesellschaft. This is a commandit partnership that is not limited by shares. Otherwise, it would be considered a company. Or an LLP, which is a limited liability partnership. Now, the difference between an LP and an LLP is that in the case of an LP, limited partnership, there's usually one partner that has unlimited liability and one partner that has limited liability. And that will have a consequence in registration, as I will explain later. Whereas in the case of LLPs, all partners have limited liability. And some cases which are not as common, which are usually involved in the offshore world, are LLLPs. So that is a limited liability, limited partnership. It's hard to pronounce. Or we have international partnerships. And these are very similar to international companies. So these are partnerships that are created in one country, but they are not allowed to operate in that country. So they may not have assets in that country, get involved in transactions in that country. They may only operate abroad. What are the transparency risks of partnerships based on our experience? In some cases, they don't need to be registered, and that is especially the case if they have no legal personality. In other cases, even if they have a legal personality and they have to register, it is very common that only unlimited partners have to register, but not the limited ones. So what could happen is that a person might remain hidden just because he is the limited partner of a limited partnership, and not the unlimited one. And again, what might happen is that if the partnership is fiscally transparent and the registration only happens with the tax authorities, what might happen is that either the registration or the update would only be required by the partners themselves and not by the partnership. Now, if the partners forget to do it or they're not even based in that country, it might be very hard to enforce this. Now, if we look at the scheme, at this diagram, and we think of company 2, what might happen is that this company 2 might be owned by a limited partnership from a different country. And when we try to find out who owns this limited partnership, when we go to the register, we find out that only the unlimited partners are registered, but not the limited partners. So if the beneficial owner was a limited partner, we will actually have no information about this person. Now we're moving to a more complex case, which is the case of foundations and Anstalts. Now, the interesting thing about foundations and Anstalts is that they have a very similar structure as trusts, and that is way more complex than the structure of a company or a partnership, but they are considered legal entities. So they do have to register or incorporate in most cases. So as I said, they have to incorporate or register in most cases, but they do not have owners. They do not have just shareholders or a member that are usually all the same. A private foundation or an Anstalt has different types of parties. In most cases, what we have is the founder, who is the original owner of the assets, and the founder transfers these assets to the private foundation that he has created. He might appoint a protector to make sure that the foundation council, who is, because the members of the foundation council will be administering the private foundation and the assets. So the founder might appoint a protector to make sure that the foundation council will do as he or she wants. And the private foundation will have beneficiaries who might be, again, members of the family, might be the founder himself or herself, but these may also be discretionary beneficiaries, so anyone that the founder decides. And then Liechtenstein is, as far as I know, the only country that offers the Anstalt, and that is called, sometimes translated as an establishment, which is very similar to a foundation or a trust, but it has a legal personality, so it has a founder. According to some papers, the founder usually uses a trustee so as to not appear on the documents and to remain hidden. And then either the holder of the founder rights will administer and manage the Anstalt, so that might be the founder or whoever the founder decides. There may be beneficiaries or not, and if there are no beneficiaries, then the founder is the beneficiary. And strangely enough, the Anstalt may also issue shares. So the Anstalt is a very also complex kind of entity. The most common ones are the private foundation, the Stack from the Netherlands, the Privatstiftung from Austria and other countries that speak German, or Fundación Privada, such as the one from Panama. And then we have hybrids, such as the case of the Anstalt from Liechtenstein, or a foundation company, which is a new case from Cayman, where what they have is something in between a foundation and a company. So it is a company, but it has the ownership structure more closely of a foundation. What are the transparency risks? One risk is that in the case of registration, only the members of the Foundation Council have to be registered, but not anyone else. Or that if the foundation has discretionary beneficiaries, and that is when the council decides who the beneficiary will be, then they will not identify any beneficiary because they are all discretionary. So they are not predetermined. They could be anyone. So what might happen is that only beneficiaries that receive the distribution would be identified as such, but not anyone else. And that takes us to the last case of legal vehicles, and that is a trust. And the main problem with trust is that they are considered legal arrangements, so they are hardly ever registered in most countries. So even though, or unlike legal entities that usually have to register so as to exist and to be legally valid, trusts do not need to do so. They exist just because someone wrote a paper. That's the case of an express trust. Sometimes there is registration, but that is only with the tax authorities. So again, they might invoke confidentiality, so it might be hard to find out whether a trust has registered or not with the tax authority. And even in those cases, registration usually happens under certain circumstances. And those circumstances being when the trust is subject to tax, but that will depend on the tax rules of each country. So this can get very complex. Now, similarly to foundations, trusts do not have owners, and they're not an entity. So they don't have owners. So as we will see, and as you can see from the diagram below, the ownership structure is the control structure is very similar as to that of a foundation. But what is interesting from the trust is that it is not an entity. So it is not that the assets are held by the trust, like it is held by a company or by the foundation. It is actually the trustee who holds the assets, or the trustee, the assets, the trust fund, the trust assets are under the trustee's name, but there is still a separation of assets. So the trust fund, the trust assets do not belong to the trustee's personal assets. So that means the trustee cannot do whatever he wants with the trust assets. He must do exactly what the settlor said. And at the same time, the creditors of the trustee cannot reach those assets because they do not really belong to him or her. They are under his or her name, but they do not really belong to his or her personal property. So it is a very, in a way, complex, or at least contradicting, in a way, concept. So the way a trust works is that we have the settlor, who is the original owner of the assets, and he transfers these assets to the trustee, who will hold them under his or her name, but not on his own benefit, but to benefit the beneficiaries. So the trust fund will be held by the trustee, but on the benefit or for the benefit of beneficiaries. Now the settlor, especially if we have a discretionary trust, where the trustee has discretion to decide who will be a beneficiary, who will get a distribution, when and how much, the settlor, what he might do is appoint a protector or enforcer, or write a letter of wishes where he gives instructions about what he or she wants the trustee to do. Originally, we could think of a father, the settlor, giving money or the land or something or a house to the trustee, who was a friend or a brother or a lawyer, for him or for her to manage the assets in the benefit of his children and spouse, the beneficiaries. But what we have now is not only discretionary beneficiaries, again, when the trustee and when the trust can decide who will get what and when, but we might also have classes of beneficiaries. So we do not identify any person specifically, but we just say the grandchildren of X, or the victims of this accident, or the refugees of Syria, whatever we want. And in some cases, the trust doesn't even have beneficiaries. And instead of that, it simply has a purpose, a reason of why it exists. And that purpose might be to hold shares of a company. So it has no beneficiaries, so no one will be identified as a beneficiary. Only the purpose, which is obviously just a concept. So what are the common types of trusts? We have the express trust. This might be revocable or irrevocable. If it is revocable, then the settlor might say at some point, okay, now I just revoke the trust, all the assets come back to me and I become the owner again. We might have a discretionary trust, which is the one that I just explained, where the trustee has discretion to decide who will get what and when. And why would you use this? This is used for two reasons. First, for asset protection trust, for asset protection. And that means if you don't want your assets, your money, to end up in the tax authorities or in a creditor, what you would do is that the trustee that has discretion would never ever give a distribution, would never ever give any money of the trust to a person that is bankrupt, or to a beneficiary or a potential beneficiary that has a creditor. So he would only give a distribution, if he gives one, to a person who doesn't have any creditors. And at the same time, since all of these beneficiaries are merely potential beneficiaries, they only have contingent interest in the trust, but it will depend on the trustee whether they get something or not. They will not be identified as the owners, because what they can say is like, hey, I don't own anything yet. I may own something in the future if I get a distribution, but so far I only have a contingent interest, so I shouldn't be registered. And that is actually what many countries do. We may also have purpose trusts, as I just explained, where there's just a purpose, or charitable trust, which are similar to foundations, which aren't private foundations. So a foundation that is used for charity or for education, for sports, for religion. That is common in many countries, but at the same time, they are supposed to be supervised just because they usually have some tax benefits, but the supervision and the enforcement is not always very good. So they may also be and have a risk. And then we also have some specific cases of trusts, such as some tax haven trusts, where we have the case of Cayman's Star Trust or the BVI's Vista Trust, and these are specific types of trusts used for specific purposes. In the case of the Vista Trust, what you can manage is that the trustee actually has no power whatsoever, and it's actually the settlor or someone holding owning a company that is really in charge. Or in the case of a Cayman Star Trust, what you have is that the enforcer has the rights to enforce the trust, and the beneficiaries have no right whatsoever other than to receive the distribution, but not to decide on anything or ask anything about the trust. What are the risks and the transparency risks of trust? The main one, as I have said, and as many others have also said, is that there is no registration at all, or the registration is only with the tax authorities and only if there is a local trustee, or if the trust is subject to tax. And again, this will depend on every country. So there may be many cases, and this happened a lot with New Zealand, that had tax rules that were very different from other cases. So a country would say, I don't register the trust because the trustee is not local here. But then New Zealand would say, I don't register the trust because the settlor is not resident here. So you would have many trusts which had no registration at all. And this happens in many cases. At the same time, what happens in many countries is that since many countries do not have a local trust law, and that means that you cannot create a trust according to the law of that country, they would simply have no regulation and no provision at all about trusts. But what they are forgetting is that a person, a local resident from that country, might be a trustee of a foreign law trust. So someone in Indonesia, even if Indonesia didn't have any trust law, might still be a trustee of a UK trust or of a Jersey trust. So countries should have provisions whenever a trustee is administering a trust in the jurisdiction, regardless of where the trust law is from. Or also, just because in the ownership chain of a company, when we are trying to reach the beneficial owner, there might be a trust or a foundation involved. So if the country doesn't have any provision about trust or foundations, it might be impossible to know who has to be identified as a beneficial owner in case a trust or a foundation appears as the owner of such an entity. That is why countries should be regulating these, even though many of them don't. And again, trust might have discretionary beneficiaries or the protector, which are hardly required to be registered under the laws of those countries that do require some kind of registration. So just to finalize with this scheme and diagram, we might have in the joint venture that company number 3 is actually held by a trust, and the trust is not registered, or even if it is registered, only the trustee is registered, but we have no idea who is the settlor or who the beneficiaries are or who the protector is. And now all of these risks can be combined. So we can have a joint venture, which is a very common way to engage in the extractive industries. And we might have 4 different companies. And again, one involves bearer shares, the other one involves nominees, one involves a limited partnership where we only know who the unlimited partners are, but we don't know who the limited partners are, and one might involve a trust. And this might actually not involve just one tier or 1 or 2 layers, but many more. And these may be combined, and we can think that even in the case of the trust, the settlor or the beneficiaries or the trustee, they may not even be natural persons, but they might even be companies. So we might have a beneficiary that is just a company. So then we would have to know who controls the company, who is actually the beneficiary of a trust. So as you can see, things can get very, very complex and very complicated. But don't worry, we do have some solutions which are actually quite simple. So the risks might be complex. If we try to identify every type of company, this may be very complex, but the solution and the ideal law is actually quite simple. So what are the solutions? Basically, all countries should require registration with a government authority of all types of legal vehicles. All companies, all trusts, all partnerships, all foundations, anything and everything that might engage, which is not a natural person, and that might hold assets or engage in business, everything should be registered with a government authority. And they should not only be registered so as to exist and to become legally valid, but they should also register their beneficial owners. In the case of companies or partnerships, that should involve all shareholders or members or partners, at least anyone holding 25% of ownership or voting rights, but ideally the threshold should be much, much lower, and ideally anyone holding at least 1 share or anyone who has at least 1 vote should already be considered a beneficial owner and should be registered. Now, in the case of a trust or a foundation or an Anstalt or a similar arrangement or entity that doesn't have shareholders but has a settlor or a trustee or a beneficiary, then all the parties, all the settlors, all the trustees, all the beneficiaries, all the protectors, and anyone else, all of them should be registered as a beneficial owner, regardless of the percentages of interest or rights that they have in the trust or in the foundation. And obviously, it is important to require the update of all the above information, either upon any change or at least annually. And 3 more points which are important. Bearer shares should be completely prohibited, and all of the pre-existing ones should register with a government authority, and any unregistered bearer share should be cancelled, not suspended, but cancelled for good. Nominees, if they are allowed, should never be considered a beneficial owner. So if a nominee exists, then he or she should identify as a nominee, and then the real beneficial owner who is behind him or her should be identified. And of course, beneficial ownership registers should be centralized, allow public access, and then be published in an open data format. Now, how could you find out what is the case in every single country? Well, the main source that we offer, which is our work, is, as I said, the Tax Justice Network's Financial Secrecy Index. This is a database and an index that is publicly online and for free. And if you Google Financial Secrecy Index, you will find this page. And then if you click there to see the full index, you will arrive to this other page. And after you register once for free with an email, just by clicking on the FSI value column of any country, any of the 100 countries, you might find the full technical database report about each country. And as you can see, I mean, I don't expect you to read everything, but as you can see to the right, almost to the bottom of each technical report, we have this analysis that I have just made about companies, trusts, foundations, and partnerships, where we identify for each country which is the most problematic type of company or foundation or partnership, and what the risks are. So if you're ever involved, or if you ever see a company, say from Panama, or a foundation from the Netherlands, or a trust from the UK, you might see, or you may find out what the main risks are, if any. Well, thank you very much for your attention and your time. And here there's also a list with the links to all of our papers. For instance, the first one is a checklist where we have this checklist for beneficial ownership registries. So for anyone trying to set up a register, here they can know, again, what type of entities or vehicles should be subject to registration, what information should be registered, what the register should look like, and everything. And then all these other papers are some typical loopholes available and how to solve them. So thank you very much, and I will be available now for questions.